guys, it's attorney Aaron Watson. I'm just returning to the office from mediation, and I'm going to talk to you. Some of you may not know what civil litigation is, and certainly what a personal injury lawsuit is. So I want to go over some of the basics, what you should know about a personal injury lawsuit, what it consists of, and what the process consists of. And so to initiate a lawsuit, the person who's been damaged or injured must complain. Complain to who? Complain to the court. They have to submit a document called a complaint. And all that document does is what it says it does. You submit a complaint to the court. And so the document will say, court, on this date, I was driving my vehicle. I was stopped at a red light when the defendant, Bob Jackson, was texting and driving, failed to pay attention. He collided into the back of my vehicle at 30 miles an hour. And so I would then demand money from Bob Jackson. I'd say, as a result of this, Bob Jackson's negligence, I incurred medical expense, pain and suffering, mental anguish, future medical expense, lost wages, lost income, lost earning capacity. You list out all the things that you've lost as a result of Mr. Jackson's negligence. And what would happen is that you sign the complaint, submit it to the court, and the court's going to issue a summons. And essentially what that is a document that notifies the defendant, hey, Mr. Jackson, you've been sued. That document is served with a copy of the complaint upon the defendant. So Mr. Jackson would probably get a knock on his door from a process server. Could be a law enforcement officer. And they knock on the door and say, hey, Mr. Jackson, you've been served. That document is going to say, hey, you've been sued by the plaintiff. You have X amount of time to respond to the lawsuit, or we're going to enter judgment against you. So the first thing is, you have to understand that there is a penalty for failing to respond to a lawsuit after you've been served. And so certainly if you've ever been served with a lawsuit with a summons, you want to treat it like it's a fire. What most people don't know is that their own automobile insurance company will provide a defense in most cases for personal injury lawsuits. And so if you've been involved in a car accident and you happen to get served with a lawsuit, the first thing you should do is call your insurance company to make sure that to see whether or not this is covered. The insurance company may very well pay for your lawyer, pay for the defense, and will have a lawyer respond to the lawsuit. The response to the lawsuit, say for example, remember in the complaint, we stated on this date, Bob Jackson was negligent in the operation of his vehicle. That's the first paragraph. The second paragraph was, hey, as a result of his negligence, I incurred medical expense and all these various types of damages. And in that document, you also demand a jury trial if you want to go and try the case in front of a jury. And so Bob's going to get a copy of that, and he's going to look at that paragraph and say, hey, I'm going to respond to this complaint. I have something to say about it. And so for the first paragraph, he's either going to admit that that allegation is true, deny that the allegation is true, or he'll say, hey, I don't have sufficient knowledge to say one way or the other. And so for the first paragraph, if he was driving negligently and he admits that, he'll admit it. He'll just write admit by paragraph 1. You rarely see that. In some cases, you'll get a defendant say, hey, I was in the wrong, and they'll admit the allegation. But the defendant, Mr. Jackson, may very well say, hey, I didn't do anything wrong, so I'm going to deny the allegation. Or he may say, well, certainly he would know whether or not he was negligently driving, so he would either admit or deny. Then you go down to the second paragraph of the plaintiff's complaint, and that paragraph said that the plaintiff incurred medical expense and various damages. The defendant may very well say, hey, I don't know what medical expense this person incurred. I don't know about any other damages. So he may very well deny that paragraph, or he may say, hey, I'm without knowledge. But he's going to go through and either admit or deny or state that he doesn't have knowledge with regard to all the paragraphs in the lawsuit, and then file that, and that document is called the answer. That's the response to a lawsuit. And so that's how you initiate a lawsuit. The plaintiff files a complaint, the defendant files an answer, and then the case proceeds into what's called discovery. Before we get into discovery, I do want to explain what a lawsuit is for, what a civil case is about. And listen, I'll be straightforward with you. A lawsuit is about money damages. Certainly if you cause injury to someone, you permanently injure someone's neck, back, knee, if it's not going to get better, there's no way you can, as a defendant, fix it if the if the medicine says it's not going to get better. So the law says that that person who was injured by you is then entitled to money damages, whether or not it's permanent or not. You know, if they went to the doctor and incurred $1, then you're responsible for that dollar. At least that's what the plaintiff is going to argue. And so the purpose of a personal injury lawsuit is money damages. It's not to fix the person's neck or back. And when I say that, you know, the defendant comes and hires a doctor to come and treat or try to fix the plaintiff's neck. It's about money damages. The plaintiff says, hey, pay me money and I will go and pay my own doctors and be compensated or try to be made whole from the lawsuit. And so whenever you see a lawsuit, civil case, more than likely it's about money damages. And so the plaintiff has complained to the court. The defendant has answered the complaint. The case proceeds to discovery, and all that is where both sides discover and exchange information about each other. The plaintiff may send over questions to the defendant and say, hey, were you texting at the time of the collision? Were you distracted? How many motor vehicle accidents have you been involved in? Were you injured in the collision? Were there any witnesses to the collision? Do you have any photographs of the collision? Did you take any cell phone video of the collision? So they'll ask those questions, and the defendant has to respond to those questions under oath. Those are called interrogatories, and the defendant can very well send those same questions back to the plaintiff. Plaintiff, what were your injuries? What were your total medical bills? Do you have automobile insurance? Do you have health insurance to help pay for these medical bills? Have you been involved in any other collisions? Did you take any video? So we're exchanging information. Another mechanism to try to discover information is what's called a request for production, where the one party will say, hey, produce to me documents, tangible items. So produce to me a copy of your automobile insurance policy. Produce to me any photographs that you've taken from the collision scene. Produce for me your vehicle so that I can inspect it and take photographs of it. So we're exchanging information. Another mechanism that the parties use is deposition testimony, wherein one party can say, hey, I want to talk to you in person and take your testimony. And so at that deposition, the court reporter will swear in the witness, and your lawyer, or if you're pro se, you can ask the questions on your own. You know, say, hey, sir, tell me what happened on this date. Were you driving this vehicle on that date at 10 a.m.? Yes, I was. Tell me what happened from the time you stuck your key in the ignition to the time of the collision. Oh, well, I got in my car, started it up, and I was driving, and, you know, A, B, and C happened. And you'd ask, you know, were you on your cell phone? Did you use your cell phone at all that day? Who did you call? And the reason you're going to ask those questions is because you probably request for them to produce their cell phone records, bills, or you can subpoena those documents from the cell phone company. But a deposition is just sworn testimony under oath, and both parties can request depositions of each other. And so you also, so you have interrogatories, requests for production, depositions. You can do requests for admissions, where you simply ask the other side to just admit or deny certain things. Sir, admit that you were under the influence at the time of the collision. He'll have to admit or deny them under oath. And so that helps to kind of parse down what the issues are for litigation. After the discovery period is done, the parties will likely be ordered by the court to do what's called mediation, and that's where a neutral party, a mediator, will come in to try to help the parties get the case resolved. The mediation is essentially a numbers game. It's all confidential. The plaintiff will come and say, hey, I demand that you pay $500,000, and the defendant will say, hey, I'm not paying $500,000, but we will offer you $50,000, considering the evidence that we discovered throughout the lawsuit. And the plaintiff will say, hey, I won't take 50, but I'll take 475. And so the parties go back and forth. At some point, one or two things are going to happen. One, the party's going to say, hey, we can't get it resolved, there's not enough money. Or two, the parties will get it resolved. And if it resolves at mediation, the case is essentially over. The parties will sign an agreement saying, hey, the case is over, the lawsuit will be dismissed, and that's the end of the case. If it can't be resolved in mediation, the case will proceed forward to trial. One of the parties will notice the case for trial, let the judge know that, hey, we're ready for trial. We've done all the discovery. We've done our due diligence. We're ready to present all of the information we've learned in discovery to the jury. And so that's essentially what a trial is where both parties present all of the evidence, all the information that they've learned to the jury. And so at a trial, the judge may say, hey, I'm available on January the 20th to try this case. And so the parties would go in, pick a jury, and all that is where folks get jury summons and they come in and the lawyers ask them questions to make sure that they're the right juror for this case, to make sure that they're not biased, to make sure that they can fairly listen to all the evidence and come to a decision in the case. The lawyers will pick the jurors. Those jurors will be impaneled, and then they begin to listen to the evidence as the parties presents it. The plaintiff goes first. He'll make an opening statement. Members of the jury, this case is about justice for my client. On this date, she was stopped at a stoplight. The defendant, at 50 miles per hour, barreled into the back of her vehicle, causing serious and permanent injuries to her neck, to her back, injuries that she, to this day, will have to suffer for the rest of her life. She's going to incur future medical expense. She's entitled to pain and suffering damages. And you're going to hear testimony on the stand from Dr. So-and-so. He's going to tell you that these injuries are permanent. They won't go away. And he's going to outline for you what it's going to cost for the plaintiff to treat over the rest of her life. So the plaintiff's attorney or the plaintiff will make that, they won't argue. You can't argue an opening statement. They'll just make a presentation as to what the jury should expect throughout the trial. The defense will get up and say, hey, members of the jury, let me tell you something. Our doctors say completely or give completely opposite opinion from the plaintiff's doctors. You're going to hear Dr. So-and-so say that he examined the plaintiff and he disagrees. He does not think that she's permanently injured. He disagrees that she was hurt in the accident. You're also going to hear from an investigator that we hired. He's going to say he followed her around and A, B, and C. And so the defense will present their side of the evidence, and then the case will proceed into not cross-examination, but direct examination. We'll start to put witnesses on the stand. The plaintiff may call the law enforcement officer to give testimony. He or she may call witnesses from the scene of the collision. The plaintiff, him or herself, may get on the stand to talk about what happened in the incident and how it's affected them. We also call witnesses that are knowledgeable of the plaintiff, how she was or he was before the accident, how they are after the accident. The doctors who've treated the plaintiff may come to trial or give video testimony as to their experience with the plaintiff. And the plaintiff will rest the case once they've put in all the evidence. They'll put in all the medical records. They'll say, Your Honor, we move to admit Exhibit A, which is plaintiff's medical records, into evidence, and then all the medical bills into evidence, all the photographs from the collision into evidence, and rest their case. And so once they the plaintiff has put their side of the evidence into evidence, and all that means that the jury is going to consider it. They can take it back there to consider it when they're trying to parse this out, when they're coming up with a verdict. The defendant then starts with their case in chief, is what we call it. So the defendant may very well remember the investigator to come testify. They may call their own doctor to come testify. They may very well put the plaintiff on the stand and ask him or her questions. Once they're done presenting their side of the evidence, they then rest their case in chief, puts in all their documents into evidence, and the jury at that point has all the evidence. And the lawyers at that point then argue what they believe the evidence shows. So the plaintiffs can get up there now and say, members of the jury, you remember when Dr. So-and-so was on the stand, the defendant doctor, and I asked him, Doctor, how much money have you been paid to examine my client on the case? And you heard what he said, $30,000 to see my client for 30 minutes. That's $1,000 a minute, members of the jury. And you know why he reached the opinions that he reached. He got paid very well to give those opinions. And so you'll see the lawyers start to make argument, and say, listen, look at this evidence. Look at that piece of evidence. Look at what they did. The investigator has been following our client around. He only showed 3 hours of her day. He didn't show the rest of her day. Why not? Why did he only show you one part of the video and not the other part of the video? He's been sitting in his car videotaping the client here for 2 weeks. Why did you only see 3 hours and not the entire 2 weeks? And so those are the arguments that the lawyers will make. They'll say, hey, members of the jury, we're going to ask you to compensate our client. You heard what the doctor said. This isn't going to go away. She's going to need this treatment for the rest of her life. The lawyer will likely make a demand or a request to the jury. We're going to demand $1 million or $100,000 in the case. And the defense will get up there and say, listen, $100,000, $1 million, this case is at most $10,000. You know, so they'll come up with their side, make their arguments, and then the parties essentially rest, you know, and say, hey, you know, it's up to the jury at that point. And so the jury gets all the evidence. They think about what the lawyers have said, what all the witnesses have said, and they go back to deliberate. And you know, it may take an hour, may take a week, may take 2 days, may take 6 hours, but they'll go back through, sift through all of the evidence. Sometimes when I'm in court, you can hear the jurors back there arguing with each other, you know, and debating and all that stuff. But they all have to come to an agreement. They'll come out and say, members, Your Honor, we've reached a verdict. The judge will then look at it and let them go and read their verdict, and they'll say, we the jury find A, B, and C, and that's your trial. And so this is a basic rundown of a trial, a personal injury trial. What happens after a lawsuit is filed? A good number of these cases never see a courtroom. A good number of them settle out with the insurance company, but there are cases. We have several cases here at the firm that are in litigation that are working towards a trial, and certainly. If you ever go to the courthouse, you'll see these trials going on. They happen every day. Both civil trials where there's money involved, and then criminal trials where the state is trying to punish someone, you know, for breaking the law. And so you're more than welcome to go to the courthouse and check them out. But certainly if you have any questions about what a lawsuit consists of, what a personal injury case consists of, you can give our office a call. If you have a potential case, we do free case evaluations. If you call and say, hey, I just want to know what you think about this, Mr. Watson, or ask one of our other attorneys to just get their thoughts about the case, you're certainly welcome to do that. If we do get involved on the case, we work on a contingency fee. And you hear those words all the time on TV, on websites, contingency fee. All that means is that lawyer is not going to get paid unless he wins your case, unless he gets money for you. His fee is contingent upon him winning the case, recovering money for you. And so certainly, you know, if you have a case, like I said, just because you watch this video about a lawsuit doesn't mean that your case is going to make it all the way to a jury trial. It may very well settle at mediation. It may very well resolve in pre-suit negotiations. But certainly when we get involved on the case, we begin to preserve evidence as if we're going to prosecute the case in front of a jury. Certainly, we thank you for watching this video. Visit watsonfirm.com. If you have any other questions about our firm, I look forward to hearing from you.